So this follows on from our earlier modules. So if you are interested and you do want to view the earlier ones, they are available on YouTube and the PowerPoints are available via our website. Just a few housekeeping tips before we get started. Just making sure that everyone knows that their lines are muted, just so it doesn't interfere with the webinar. But if you do have questions, there is a chat box function with the program, and you can always type questions in, or at the end of the webinar, I'll try and leave the webinar open for a few more minutes to answer any questions that people might have. So feel free to use that function, and obviously at the end of the webinar I'll also provide some contact details that you can get in contact with us if you do have any further questions after the chat box closes. And obviously you'll know from our earlier webinars that we do provide information, advice and advocacy for children and young people, so obviously feel free to call our services at any time if you do have a general query as well. Other housekeeping tips, if there are a number of people logged on one computer, I'd really appreciate if people could just type their names into the chat box so we can get a gauge of the individual people that are logged in on one computer, just so we have total numbers for accounting to the Ministry of Justice for the webinars we run. And also at the end of the webinar, we'll be sending out a survey via SurveyMonkey just to ask you how you found the webinar and whether it was useful, and would really appreciate if you're able to fill that in and let us know. So let's kick it off. You'll remember I've talked a lot about different aspects of discipline and education law and the right to education in earlier modules. Today I specifically wanted to focus on search and seizure in schools. So what are the limits of the school's authority to search a student? When can that come about, and when can they challenge it? So there's been a few changes to the law. Before, there wasn't really a lot of law that was specifically governing this area. So we had general laws like the Bill of Rights and things like that, which protect people against unreasonable search and seizure. And you'll remember I talked a little bit about that in earlier webinars. But nothing that really specifically dealt with the school environment and how teachers or principals or relevant people associated with the school could carry out searches and what the limits of their authority were. Were they sort of, acting in place of a parent? So you remember in Module 1 I talked about this concept of loco parentis and the idea that schools used to be seen as in the place of parents while students were at school for the school day, so having some sort of parental responsibilities. Or were they more like police officers, so sort of more impartial, seeking to investigate a crime, and how would they go about that, and were the limits similar? So given that there was a lot of variable and inconsistent practices, a lot of this was clarified with the recent rules that were published. So the relevant rules, and the full name of them is there up on the PowerPoint, the Education, Surrender, Retention and Search Rules 2013. Ministry of Education had input into these and essentially issued some rules to help schools govern their discipline of students and how they would undertake searches and any seizure of items from students, because obviously it's got to be consistent with things like the right to property and the right to be free from cruel and unusual punishment. So you remember I talked about a little bit about that last time with the Bill of Rights as well. So the principles are set out with the rules. So the principles contained in the rules state that schools are required to provide a safe physical and emotional environment for students and staff. Parents, students and the public have a legitimate expectation that a school environment is going to be free from drugs, weapons, alcohol and cyberbullying, and this feeds into the obligation of schools to provide a healthy and safe environment. You'll remember I talked a little bit about that in one of the earlier modules. So it is required that schools develop written policies and procedures on search and retention. So that would be best practice. Essentially, the guidelines are there in the rules, and then schools should have their own school rules and ways of dealing with these processes as well. Other principles include the fact that the schools must act reasonably and in good faith. So they must, do their best to maintain a good and working relationship with the student and their parents, and do that in a manner that is in the least intrusive manner to achieve a safe environment for the greater good of the school. So the Bill of Rights Act 1990 still applies. You remember I talked a little bit about this in one of the earlier modules, and about the fact that it's not entrenched or protected legislation. So it's just on par with other laws that we have, but essentially it sets out those basic rights that we're all pretty familiar with. So right to be free from discrimination, right not to have your property unreasonably searched and seized and things like that. Section 21 of the Bill of Rights Act sets out that everyone has the right to be secure against unreasonable search or seizure. In schools, in accordance with the Bill of Rights Act and also these rules that have recently been published, need to justify their actions as reasonable and necessary to maintain a safe environment. So that's the key thing. It's sort of a utilitarian, greater good, best for the whole school environment sort of approach. So there are a number of items that can be seized by a school, so they are in a position of authority. So the rules essentially set out the parameters of that and how they must deal with anything that is seized in the case that they do search or seize something from a student. So the law or rules refer to three types of items. Firstly, those that are likely to endanger the safety of others. So think about a student that brings a knife to school. That likely would endanger the safety of other students, and the school might have a legitimate interest in seizing that item from the student, even though it is their property and a person has the right to be free from unreasonable search and seizure. And the rules give more detail to this in the school context. Secondly, items that are likely to detrimentally affect the learning environment. And thirdly, those that are harmful. So anything that poses an immediate threat to the physical or emotional safety of any person. So one of the key points I really want to drive home in respect to the rules is that the rules are really clear that there does need to be an immediate threat in order to justify actions that a school does take. So you can't sort of say, well, in 2 months' time this is going to become harmful, because it probably is not going to meet the threshold for an immediate threat to take action and actually impinge on that student's rights to freedom of possession and freedom of movement or something like that. So, surrender and retention. If a teacher or staff member has reasonable grounds to believe there is an item on a student's person or in any bag or container that's in the student's control that's likely to endanger the safety or detrimentally affect the learning environment, under Section 139 AAA, so quite a bit of a mouthful, but essentially, the rules are your go-to point. You don't necessarily need to remember each section individually if you're providing support to a young person, provides the authority for a teacher or staff member to sort of engage in this surrender and retention process. So there's a key distinction here between school property and what the student's property is, which will inform whether or not the relevant staff member or principal has the authority to undertake this process. So it's important to bear in mind that a school can at any time search any of its property for any reason because it's their property. So this includes school computers or digital property of the school. So if they've given students iPads, the school has the right to seize those at any time and conduct a search on them at any time because the student is using the school's property. It's quite different when you're talking about a student's individual private property. So say a student brings their smartphone to school, there's no ability to force a student to reveal a private email password on a smart device. But this would be quite different if this was software that the school had installed on a private device. So it's the school's software, and say the student had engaged in conduct which was harmful to the school or generally, so for instance had threatened to hurt another student on that forum, the school would be empowered to go in, search that device, and force the student to reveal whatever was used on that school account because it's the school's property, and the student presumably and hopefully, if the school's got in place processes to protect around this, probably would have signed an internet usage agreement or some sort of agreement with the school, empowering the school to take action in these circumstances. Of course, these sort of agreements have to be reasonable as well, so they can't be wide-reaching and say that a student must reveal their private personal details or private personal emails or anything like that. if it's, for instance, a Facebook site. So recently, I think some of the cases we've come across in our advice line have involved really wide-reaching sort of internet contracts or media contracts, and in some of those cases, our advice has certainly been that the parameters of those contracts might exceed the ability of the school to actually enforce them, firstly, and secondly, they may not be reasonable in the sense of what they're asking the student to agree to is beyond the realms of reasonable in terms of privacy expectations or legitimate interests in property. So there's a distinction between devices and items. So in the rules, they're defined quite separately. A device is electronic, so that's your smartphones, your iPads, that sort of thing. It's capable of storing or displaying digital information. And the rules define items as all other things. So when I think about items, I'm thinking about things like a student bringing a knife to school or a sword or something along those lines. So there's a real distinction in terms of the rules that are set out when a staff member is dealing with a device or an item. So a staff member, and remember that with the staff members, it's got to be an authorised staff member. So the rules are quite specific. It can't be just anyone that does the search, but it needs to be an authorised staff member who has the ability to undertake this process. So a staff member may require a student to reveal an item stored on an electronic device. The staff member may retain a surrendered device but cannot dispose of it. So this is a big distinction between a device and an item, essentially, because an item sometimes can be destroyed, whereas a device can't be. A device needs to be stored appropriately with records. So the school should probably have a record system where they note, such and such was taken off Johnny today, a smartphone was taken off Johnny at this time, it's been stored in this secure facility, and it's expected to be returned to Johnny on X date. So after a reasonable period of retention, now reasonable is not given any specific time frame, but it will be dependent on the circumstances, the harm, what is legitimately reasonable in the circumstances based on the student's own expectations, the value of the device, etc. And the device must be returned to the student or an authorised person, such as their parents or the police, if the matter is such that it's criminal and it needs to be referred to the police for investigation. An item, on the other hand, can be retained and disposed of as appropriate. So a really good example is where a school may destroy drugs. So drugs may be retained and disposed of because obviously they're not going to be returned to the student, or they will be handed on to the police if a criminal investigation is pending. If a student does refuse to surrender, there are sort of some processes set out in terms of what a staff member can do. So it doesn't mean the end of the road. So if a student says, no, I refuse to surrender what I've got in my possession, it doesn't mean that the school's then stuck. They can then take further steps in respect to the student. So if a student refuses to reveal, produce or surrender an item or an electronic device, a team or a teacher or an authorised staff member can take disciplinary steps that are reasonable. So those of you that tuned into our Section 14 discipline webinar, you'll remember that I talked about the fact that there are really specific and prescribed times when you can take disciplinary action against a student. So this is one of those cases where whatever the refusal to surrender is, it needs to then fall into the Section 14 disciplinary process. And the authority for that stems from Section 139 AAAF of the Education Act. You don't need to worry about the particular sections, but you just need to know that if a student does refuse to cooperate, that the school can then take disciplinary measures against them. But again, they would need to fulfil the criteria under Section 14 and justify that such action was either gross misconduct or continual disobedience within Section 14 of the Education Act. And if you do want a bit more detail on that, definitely feel free to go back and watch our webinar on Section 14, which goes into the process in a lot more detail. But yeah, it doesn't mean the end of the road. The student is sort of in a hard position because if they don't cooperate, the school can then take disciplinary action against them, and then they may have a formal disciplinary action on their record. And sometimes with these sort of things, there are additional risk factors that play in for the student, and if you're supporting the student, it's important to note that, you know, there could be criminal elements to what the student has done, and that may mean a referral to the police for police investigation, and at that stage, you know, definitely it's probably in the student's best interest not to be completely candid with everything with the police, but seek legal advice first, get advice about whether they should even provide a statement to the police and what they say to the police if the police are investigating. So the school also has the power to search things like lockers, desks, and other receptacles provided to the students. So again, that goes back to the whole thing about school property. The school owns the device, for instance, that's given to the student. The school owns the locker, so they've got the right to search it and see what's in there. And if they find drugs, then obviously they can take appropriate steps and refer the matter to the police. And the appropriate section there is section 139 AAG. Again, not crucial that you remember each of the sections at all. There are limitations, of course, set out in the rules. So, I mean, it might have been a little murky before these rules were published, so teachers might have been doing things like this before on the basis that they thought that they had the ability to do so within, you know, general school rules. The good thing about these rules is they've really clarified the extent to which teachers can take these sorts of steps. So a teacher and authorised staff member can carry out searches of outer layers of clothing. So those are outer layers only, so we're talking about like jackets and things like that. Strip searches and any removal of clothing that is not an outer layer, and there's quite, you know, clear guidance in the rules about this, and rub down searches such as patting of the body and inserting hands into pockets is not permitted. So nothing invasive. If there's anything of that nature occurring, it's arguably in breach of the rules, and the student might have grounds to complain to the principal, the Board of Trustees, and also potentially the Ombudsman. So examples of outer layers would include things like a head covering, gloves, footwear, socks, those sorts of things. So your relevant section to refer to there is section 139 AAD. Again, not crucial you remember that at all. And any other sort of searches of that nature that are a bit more invasive would need to be referred to the police, who have appropriate powers under the Policing Act and other legislation to carry out those sorts of searches. So I'm thinking sort of, you know, things like the Misuse of Drugs Act and things like that. So also, the rules are quite clear. They set out some parameters around what the teacher and authorised staff member can do. So they must carry out the search with decency, sensitivity, in a manner that affords the student the greatest degree of privacy and dignity consistent with the purpose of the search. So obviously, sort of forcing a student to take off their outer layers in front of a group of other people or something like that would be really inappropriate, or doing it in a way which degrades them or puts them down. And also the rules also set out nice guidance saying that unless it's impracticable, a search must be carried out by a teacher or authorised staff member of the same sex as the student, and in the presence of the student and another teacher or authorised staff member of the same sex. So that's quite a key point. So you shouldn't expect to see students of the opposite sex being searched together in that manner. Also, unless it's impracticable. Now, impracticable is not clearly defined in the rules, nor is there much guidance around what is or when is impracticable. I think that will come down to individual circumstances. So, for instance, teaching staff, half of them are wiped out by a flu. You have no other male teachers who can conduct a search. Maybe that's impracticable. I don't know. It hasn't been tested in court, but could be. So unless it's impracticable, a search must not be carried out in the view of any other person other than the person carrying out the search, the student, and the other teacher or staff member. The teacher or staff member must also return any clothing or footwear removed in any bag or container. They are required to keep a written record of any item that is seized. And if the school doesn't actually comply with these written requirements, they'll need to explain why it was impracticable to do so. Again, as I said, there's no specific definition of impracticable, so it may just come down to the individual circumstances, and it'll be necessary to do a case-by-case assessment of that. Never been tested in court, so I couldn't give you any specific case examples either. But you'd hope that it is possible to comply with those obligations in most cases. And the relevant section for that is section 139 AAAC. Again, not crucial that you need to quote that section or anything like that. Just if you're supporting a young person, just knowing the limits on the searching provisions if you need to support them through that process. Also, no staff member or teacher can use physical force against a student or require a student to provide any bodily sample. So there are really strict limitations around that, obviously. Only the police have got powers to compel the production of bodily samples under specified bits of law. And so that's something that would be dealt with in the policing realm rather than by any person in the school authority sense. A student can be encouraged to participate in a voluntary drug treatment program or agree to testing. So obviously you can't force them to undergo a test, but if you say to them, we'd like you to get tested and the student consents, there's no law prohibiting that. And in fact, the school quite often can impose those conditions on a student, sometimes for return after a suspension. So you'll remember in the last webinar I talked about conditions for return on a student after being suspended, and sometimes that can be one of them. No teacher or staff member can have a dog with them to exercise any powers. So this is a nice and clear statement from the Ministry of Education around the limits of power that a school can undertake. And so if there is a dog, and we'll get to this at a later date, it's not going to be at the instigation of the school bringing the dog in. The rules also state that the powers can't be exercised with two or more students together unless there are reasonable grounds to believe that each student has an item specified on the person or in a bag or container. So just to give you an example of when this might apply, we've had cases on the advice line where whole classes have been searched because something's gone missing and the whole class has had their bag searched. So that sort of action would really contradict and contravene these rules. So if you're ever supporting a young person in that situation, it's probably quite valid for them to point out their objection and note that the rules don't allow this. It's probably too wide of an interpretation to suggest that it was appropriate to do it that way. If a student refuses to, for instance, remove an outer layer or surrender an item, then there are disciplinary processes that the teacher or authorised staff member can take. And remember, the teacher only has limited ability to take disciplinary measures. It would then need to be referred to the principal, who could then make a decision under Section 14 of the Education Act as to whether it met the thresholds set out under Section 14 for gross misconduct or continual disobedience, and whether a stand down or suspension was appropriate. So where the school and authorised staff members can't do some things, there is power in Section 139 AAA for a contractor to undertake some aspects of searching. So you remember I said before that teachers and staff members can't utilise like a sniffer dog to find drugs or anything like that, but the contractor is able to bring in a dog trained for the purpose of searching school properties, which can include lockers, desks and other receptacles provided to students for storage. So I mean that power is available. I'm not sure how often it's invoked by schools to have a contractor come in. But essentially, it's not what the rules are trying to get at is not for the school to be bringing in their own sniffer dogs and having searches. If they want to do that, an independent contractor can come in, or the matter can be referred to the police. So a summary of the requirements is that searches undertaken to locate the items and devices must pose an immediate threat to the physical, emotional safety of persons. So as I said, there's no clear definition around this. So you, first of all, as a teacher, if you're in that position, you need to have a reasonable belief that there is actually a harmful item, first of all, so it can't just be a whim. And secondly, you also need to have a reasonable belief that there is immediate risk to the health and safety, emotional safety and well-being of the student or other students in the student body. If you don't meet those requirements, I'm not sure that the teacher would be empowered to take those steps and engage in the search and retention process, and potentially that process would be open to challenge. Has it been challenged in a court of law in any cases? No, so I wouldn't be able to give you any clear parameters around that, but obviously there's a sort of case-by-case assessment of what is reasonable. So factors that a teacher might take into consideration are things like proximity to an item. So if you're right by the smartphone, it's on the student's desk, and the student's exhibited behaviour. So if it's quite clear that a student is very upset or at risk of being harmed, perhaps that would be a good indication. Another example would be students whipped out a knife, exhibited behaviour as they're looking quite aggressive, probably, definitely ticks the box for immediate threat of harm, proximity to item and exhibited behaviour. And yeah, as I said, if there is any retention of an item or device, so for instance, a student brings to school a really expensive samurai sword that they bought online. It's quite high value, so it's not really appropriate, probably from a reasonable perspective, to dispose of the student's item unless there's very special circumstances around that. The school may wish to retain it or store it or keep it in secure holding. So if it is retained overnight or longer, the school has a clear obligation under the rules to store the item securely. So yeah, sometimes we hear cases where items aren't stored securely and damage occurs, and then that becomes an issue of sort of bailment law, which is to do with holding of an item for safekeeping and a civil claim essentially between the parties. I won't go into too much detail, but essentially, the parties might say, well, I'm not very happy with what's occurred, and it could end up in the disputes tribunal. There should be written records outlining the procedure that was taken and a clear inventory of items taken. So, it is very similar to the stuff I talked about in my earlier webinar about the fact that if you're going to take a procedure with a student and do an investigation, much like if you're doing a Section 14 process, it needs to be properly done. It should be done consistently with the principles of natural justice. You remember I talked about natural justice, and being fair to the student and documenting the process that you undertake and making sure that it's fair. And the inventory of items is a protection also for the school, because if the student then says, well, actually, you took 3 smartphones and I've only been given back 1, the school can clearly point to an inventory and say, well, actually, no, we only retained 1 smartphone. We have it recorded in our log here, and it was securely handed over at 4:20 p.m. or whatever time it was. So, again, I sort of keep talking about the legislation, but in making decisions, school boards and staff will need to be mindful of the impact of the Bill of Rights, the Human Rights Act and the Privacy Act. So remember I talked a little bit about the Bill of Rights Act already, the fact that people have the right to be free for unreasonable search and seizure. The Human Rights Act, so people have the right to be free from discrimination. So just because a student has a tattoo or, another instance that we might have had cases in is a child may be a child of a gang member. That does not mean that the school has the ability to then essentially subject them to extra search and seizure processes just because of their family status. That would breach grounds for discrimination on the basis of family status. In the Privacy Act, so like I said before, there are things like not requiring a student to reveal their personal email password. That would be in breach of their own privacy and legitimate expectations of privacy and property in the internet realm. So there are lots of things that sort of weigh in and affect the rules. And the good thing about the rules is they provide a lot more clear guidance for schools on the limits of their authority. And obviously in cases where further investigation is required, it may be a case which is required to be referred to the police for a criminal investigation or otherwise. So here are our top take-home tips. So just remember the distinction between school property and private property. Essentially, any school property is subject to search, and the school doesn't have to justify it or explain it because it belongs to the school. But there are requirements around how students can be searched and limits to how that can occur. And in some cases, the school shouldn't be doing anything except for referring the matter to the police. Schools can also only retain property if it's property that's appropriate to retain, for instance, a smartphone, a device, or particularly valuable items, and retain them for a reasonable period and keep the items safe, but they do need to follow a number of housekeeping rules like logging them and securely storing them. So that's essentially all I wanted to talk about. So a bit of a shorter webinar today. Don't know if anyone had any questions. I'm just going to have the chat box open for anyone for a few minutes just to ask any questions. But here's some information on how to contact us if you do sort of have any further questions. We have a Facebook page, website, and you can also download our app, which is free, and it sets out legal rights for young people. And we really greatly appreciate if the people that are participating live in the webinar can undertake the SurveyMonkey survey. It just really helps us, and it's part of our reporting requirements for being able to put on these webinars. Feedback on how we can improve the webinars in the future is always very helpful. I'll leave the webinar chat box open for a few minutes for any questions. Otherwise, thank you very much for joining us for our webinar. I look forward to hearing your feedback on it, and we will be running one more webinar next month just about privacy and things like that as they relate to students in the school setting, and that will sort of finish off our education law modules for this year. So thanks very much, and hope to see you next time.